Clerk, please call the roll.
Wiggs, Wilson, Harris, Cagle, Carter, Cowart, Crane, Esri, Farney,
Present.
Fava, Furtado, Hanover Friedman, Lockshin, Pugh, Rodriguez, Rogers, Settles, Sexton, Sollard, Thorsland, Vantage Theronot, Locke.
Present. I will note that a quorum is not required as this is a study session, so there's 3 of us here. We're excited to learn. Will the clerk please read the notice of the meeting?
Notice is hereby given that a study session of the County Board, Champaign County, Illinois will convene on March 24th, 2026, 6:00 p.m. in the Shields Carter Meeting Room, Bidden Administrative Center, 102 East Main Street, Urbana, Illinois, in said county for the purpose of Open Meetings Act and Freedom of Information Act training.
Is there a motion to approve the agenda? Farney, second. Furtado. Any discussion? All in favor? Aye. All right, the ayes have it. Moving on, public input. Jason Benda, come on forward.
Jason Benda, 1529 Lincolnshire Drive. I am a county employee in the facilities department. I wanted, as I did last year for the Open Meetings Act training, to thank the board and our presenter today for having this training and for streaming it so that we can all of us in the county can see and review this at a later time. I appreciate the 3 board members who are here. And I hope that the other 19 will pay attention to this at some point. I understand that it's very important for board members. It's also important for anyone who chooses to serve on a board, a commission, a task force. Any of these organizations are subject to some of these regulations. And those of us who have served on boards, commissions, and task forces need to understand what our responsibilities are, even if we're not necessarily charged with maintaining those responsibilities. And also, this is good for the public to be able to see, because it's nice for the public to understand what standards the board and what standards boards, commissions, and task forces are being held to in terms of the Open Meetings Act and in terms of the Freedom of Information Act. And now that Matt has put up the timer, I'll wrap my comments. Thank you.
Thank you, Jason. And you've touched on it. We're going to have this meeting so that we can stream it and everybody can come back to this training at a later time. Seeing no more members of the public, we'll close public input. Are there any communications from the board? No one's feeling chatty? Great. Moving on, presentations and discussions. Mr. Muller, come on forward. Give us some Open Meetings Act training.
Good evening, everyone. I'm not sure that this is sharing. One moment. The impression that this PowerPoint would just show up. My apologies.
That is okay. This is why we have IT.
Lovely. All right. For those of you who don't know me, my name is Andrew Muller. I'm an assistant state's attorney with the Champaign County State's Attorney's Office Civil Division. I also serve as the state's attorney's office FOIA officer. Tonight's presentation will be a discussion of the Open Meetings Act and the Freedom of Information Act, also known as OMA and FOIA. We're going to start with the Open Meetings Act and discuss the general standards, what is a public body, what exceptions apply, what closed meetings are, and how to enter closed meetings. We're also going to discuss notice requirements, enforcement of the Act, current decisions, and have time for questions before moving on to the Freedom of Information Act. We're also going to discuss general standards of FOIA, how to read a request, what exemptions might apply, as well as voluminous request standards, unduly burdensome requests, and then common issues that we might deal with, such as repeat requesters, and also a number of updates and decisions by the PAC, or the Public Access Counselor. I also have available a number of useful resources, such as the full text of FOIA, if any of you should be so motivated as to read the entirety of it. We also have the Open Meetings Act full text, and the Illinois Attorney General's website, specifically their PAC subsection, where you will find FOIA and OMA training, as well as the previous Public Access Counselor decisions. This PowerPoint will be made available after this meeting. But who is the PAC? The PAC is the Office of the Attorney Generals that was established in 2010, which is specifically tasked with providing advice and education with respect to FOIA and OMA. They resolve complaints concerning compliance with FOIA and OMA without litigation. If a member of the public or anyone believes that there's been a violation of the Open Meetings Act or disagree with a determination made in a FOIA request, this is the body to which they appeal. Moving into the Open Meetings Act, Open Meetings Act is a statute that was established with the intent that the actions of a public body are to be taken openly and that all deliberations are to be conducted openly, and to prevent the secret deliberations of a public body. The goal is to include the public when deliberations and decisions occur, which is why the Open Meetings Act also requires that a meeting be convenient, it be an adequate space for attendance, and that the notice requirements be adhered to, such as time and place, as well as location. Now, I am going to read this full definition, so bear with me. The Open Meetings Act defines a public body. A public body is the groups that are subject to the Open Meetings Act, and this includes all legislative, executive, administrative, or advisory bodies of the state, counties, townships, cities, villages, incorporated towns, school districts, and all other municipal corporations, boards, bureaus, committees, or commissions of the state, and any subsidiary bodies of any of the foregoing, including but not limited to committees and subcommittees, which are supported in whole or in part by tax revenue, or which expend tax revenue, except for the General Assembly and committees or commissions thereof. It is nice that the Illinois legislature wrote themselves out of the Open Meetings Act, but all of the committees and subcommittees of the county board are likely subject to OMA. If you have questions regarding a specific committee or action group or advisory body, it's a good idea to reach out to the state's attorney's office and we will provide a review. There are a number of factors that determine whether a subsidiary body is subject to OMA, and we would need to review that information and perform that analysis. Please feel free to reach out to us. Each elected or appointed member of a public body, as previously defined, must complete the training that is administered by the PAC. It's available on their website. The member of the public body must complete that training one time within 90 days of assuming their position, and file a copy of the certificate of completion with that public body. For the county board, that will be the county executive's office. You'll submit a copy of your certificate. A public body must also appoint one member who is going to complete that electronic training annually. It is important to note that failure of one or more members of a public body to complete the training required by this section, or that one member not completing the annual training on time, does in no way affect the validity of any actions taken and is not a basis for any votes or recounts to be reconsidered. Now, who here is a public body? The Champaign County Board is a public body as defined by the Act. Its committees, ad hoc committees, most of its action groups, as well as political caucuses fall within the definition of a public body. Now, who is not a public body is also important to note. Employees who will voluntarily and in an interest of efficiency or good staff work meet together periodically in the performance of their duties are not subject to OMA. Informal advisory committees that deal solely with internal affairs are also not subject to OMA. And in most situations, corporations, even if they're dealing with public funds or publicly funded projects, are not subject to OMA. There are, again, some exceptions to the corporation. If you are dealing with corporations or a request regarding corporations, please reach out to the state's attorney's office. Now, a meeting is also a particular definition under the meaning of the Open Meetings Act. It is any gathering, whether in person or by video or audio conference, telephone call, or electronic means, which includes a wide variety of electronic communication, or other means of contemporaneous interactive communication of a majority of a quorum of the members of a public body held for the purposes of discussing public business. It is not, again, meetings or conferences of department heads, staff, or employees where the purpose is to promote good staff work. Those simply are not considered public meetings, unless a majority of a quorum gathers during that meeting to discuss matters of public business. The key terms are, again, majority of a quorum of a public body and held for purposes of discussing public business. Now, before we get into quorum specifically, I wanted to discuss electronic communication, specifically regarding email. There are not a lot of case law or binding opinions by the PAC on this issue. There is a non-binding opinion where the PAC determined that emails were not considered meetings. However, it's very important that we point out that that decision was based on the evaluation of the content of those emails. The members of the board or body in question were not discussing public work. They were not engaged in a deliberative process, considering whether they should vote or how they should handle a particular issue of public business. It should be noted that any email sent to enough board members has the potential to be considered a meeting, depending on how board members respond. Specifically, if further responses follow or elicit a consideration or deliberation of that topic. The state's attorney's office would recommend the inclusion of such language as, "Please let's save any discussion for the next notice meeting," as a polite way to remind your fellow board members that they should not be discussing matters of public business, particularly if the number of board members starts to rise to the majority of the quorum. Now, it is also important to remember that emails get forwarded on. If you're sending an initial email, please, on a particular subject of public business as an informational disclosure, please also include language about saving discussion for the public meeting so that it is not forwarded on and deliberation does not occur outside of the original sender. Always remember that emails are sent to more than their initial recipient, and that will be revisited during the FOIA portion of this discussion. Now, quorum, to be a meeting under the Open Meetings Act, you must have the majority of a quorum of the members of a public body, again, for the purposes of discussing public business. Now, so essentially, that is a majority of a majority. For a public body that is consists of 3 members, such as the Board of Review, a majority of that public body would be 2, so 2 would be the quorum. But then a majority of that quorum is also 2 members. Now, there is a relative scale here, because again, you're taking the majority of the initial body and then a majority of that majority. However, there is an exception to this, which is boards or public bodies consisting of 5 members. The answer is always going to be 3, regardless of what the math might tell you. Again, a finance committee would be a good example of that with 5 members. A quorum is 3, but a majority of a quorum is also 3. The county board itself, with 22 members, the quorum would be 12 members, and majority of a quorum would be 7. So if 7 members gather at a party and begin discussing public business, that is a majority of a quorum of the county board. It is also very important that you remember that many members of the county board serve in many different capacities. If you serve together on a particular committee that only had 3 members, just 2 of you getting together consists a majority of a quorum. So if you are gathering at parties, I highly recommend not discussing matters of public business, as that opens up the potential for review and evaluation and criticism. I do want to duck back one moment to the training issue, as I believe, I apologize. I do want to point out that if you serve in multiple capacities on multiple boards, you only need to perform the training once. You are one person for the purposes of the public access counselor. You only need to do training once and show to the PAC that you have done the training. You don't need to do it for every hat that you might wear. Now, closed meetings. Certain meetings can be closed to public examination and public scrutiny under specific statutory exemptions. These are highly questioned by the PAC and by members of the public who want to know what was going on. The exemptions that are invoked are strictly construed against closed meetings, as again, the intent of the act is to prevent secret deliberations. As such, they are specific exemptions that must be cited. In order to close the meeting initially, the public body must first cite the specific exemption from Section 2. We're going to discuss some of those exemptions in a moment. You must then vote to hold a closed meeting pursuant to that section of Section 2, publicly disclose the specific section of Section 2, and the result of that initial vote to close the meeting. Then record and enter that information into the minutes of the open meeting. You should always remember that no final action can occur during a closed meeting. In order to perform final action, the public body must re-enter public session, provide a summary of the essence of what occurred in the closed meeting, and then perform a vote on that particular issue. The minutes of a closed meeting must also be maintained, but there is no requirement that those minutes be verbatim. It must simply include the basics of what was discussed and be reviewed on a semi-annual basis for continued closure or being provided to the public. Specific exemptions allowing closed meetings. I'm going to read through these quickly. If any of you have any particular questions about a particular exemption, feel free to ask or reach out. A number of these exemptions, while they may sound clear as they are expressed in the statute, have been broadly or very specifically interpreted by the public access counselor, which is also something you will see during the exemptions portion of the FOIA training. The first option is appointment, employment, compensation, discipline, performance, or dismissal of a specific employee or legal counsel for the public body. 2, collective negotiating matters or deliberations concerning salary schedules for one or more classes of employees. Discipline or removal of an occupant of a public office or appointment of an individual to fill a vacant public office. Evidence or testimony received in a hearing, provided that the body is a quasi-adjudicative body and prepares and makes available for public inspection a written decision setting forth its determinative reasoning. Discussion of purchase or lease of real property, discussion of setting of price for sale or lease of property owned by a public body, sale or purchase of securities, investments, or investment contracts. And I want to specifically note item 9, discussion of pending or probable litigation against affecting or on behalf of the public body. This is one that is specifically, strictly construed by the public access counselor. In order to be considered pending or probable, it is best to have an actually filed lawsuit or a letter or other document where the individual or organization is specifically threatening to file such a lawsuit. It is not, hypotheticals are not enjoyed by the public access counselor. I'm going to skip through these. Again, discussions regarding self-evaluation, practices and procedures, this is item 13, or professional ethics with representatives of statewide associations. 14, discussion of minutes of a meeting that was lawfully closed under OMA. You can, again, there is a semi-annual review of closed meeting minutes, which is also performed in a closed meeting so that the information that was already closed does not have to be discussed in an open meeting. Discussions involving internal or external auditors and government audit committees, finance committees, and their equivalents, when the discussion specifically involves internal control weaknesses, identification of potential fraud risk areas, known or suspected frauds, and the fraud interviews conducted in accordance with generally accepted auditing standards of the United States of America. Please note that this section, again, requires those specific items to be listed, not just general discussions involving the auditor or the county finances. Public notice of a meeting must be provided with the date, time, and location of that meeting. And at the beginning of that must be provided at the beginning of each calendar year. It must be created and made available to the public. The schedule for regular meetings of that year, again, including the dates, times, and locations of the meetings. Notice shall be given by posting a copy of the notice at the principal office of the public body, or if no such office exists, at the building in which the meeting is to be held. If the public body has a website maintained by its own full-time staff, the notice of all meetings must also be posted on that website, not in exclusion of the physical posting, but as well as. If the public body then changes the regular meeting schedule, it must give 10 calendar days notice of the change by publicizing the change in the newspaper and posting that information, again, in the principal office of the public body. You must also post the agenda for the particular meeting in the principal office of the public body at the location of the meeting and on the public body's website at least 48 hours in advance of the meeting. While the public body can discuss items that are not on the agenda of a regular meeting, you cannot take action on any of those items or regards to those items in a regular meeting. That special or emergency meeting, unlike a regular meeting, a public body cannot even discuss items that did not appear on the agenda. It's why the state's attorney's office, if you do not know the specifics of those meetings, it is a good idea to include placeholders which involve the general topic, even if the specifics aren't known, as that will give you greater flexibility to discuss or vote on particular issues. Because if it's not in the agenda, it's not happening, or should not happen. The meetings must include, the meeting minutes must include the date, time, and place of the meeting, list of the members present and absent from the meeting, and whether they attended in person, by phone, or by video. Add a summary of the discussion of all matters proposed, deliberated, or decided, and a record of any votes taken. This, again, does not require a verbatim or a blow-by-blow assessment of everything that occurred in the meeting, merely a summary. Closed meeting minutes only require that they contain a summary of the discussion and can be approved, again, at a closed meeting instead of an open meeting, and must be reviewed semi-annually to determine if confidentiality for a closed meeting is still required. Violations of the Open Meetings Act. Again, this involves application to the Public Access Council for an assessment of the violation. A member of the public or any individual may make a request for review within 60 calendar days when the violation occurred. That individual can also bring a civil action in circuit court against the public body, and the state's attorney's office also has the option of alleging a violation and filing a civil action in circuit court, again, 60 days after the violation occurred or within 60 calendar days of the discovery of the violation by the state's attorney. Technically, under the state law, violation of OMA is a Class C misdemeanor, punishable by up to 30 days in jail and a fine of up to $1,000. There are also several civil penalties that are authorized by the statute, allowing the circuit court to either order a public body to conduct an open meeting on a particular topic. The court may grant an injunction against future violations by the body. The court may order the public body to make available make available to the public closed meeting minutes that were improperly closed. They may declare null and void any final action that took place at a closed meeting in violation of OMA, or reward any other relief that the court deems appropriate. And they may also allow the application of attorney's fees to the applicant for the lawsuit. Now, the state's attorney's office has not ever filed a violation of OMA, but that is a technical that is within the statute. Now, I want to discuss a couple of recent public access counselor decisions, specifically PAC decision 26001. That was the first binding opinion issued in 2026. Rules for public comment. In that case, a mayor interrupted an individual's public comment in order to tell them that they should not be stating the names of the village trustees and addressing them directly. The individual then refused and continued listing the trustees' names. The mayor then turned off the audio system and removed the microphone from the lectern and stated that the individual's time was up. Now, the public access counselor found that this was a violation of OMA, specifically 2.06G, which allows that any person shall be permitted an opportunity to address public officials under the rules established and recorded by the public body. The PAC noted that the public body had never established or recorded a rule that said that members of the public couldn't address trustees by name. However, the PAC hurried to address that even if they had, such rules need to be in the interest of efficiency and cannot be specifically limiting members of the public in their ability to address the public body. Again, these are narrowly construed with the interest of allowing the public access to the ongoing proceedings, and any rules that are established by a public body need to keep that in mind. I also wanted to point to PAC Decision 25011, which involved an improper private meeting. 7 members of a 15-member county board attended a dinner that had been hosted by an energy company. The invitation issued by the company asked them to please join them for a discussion of their proposed energy project. Their employees would provide an overview of the proposed project, updates on project progress, and the projected tax revenue benefits to the county, and answer any questions. Now, the OMA defines a meeting, again, as any gathering of a majority of a quorum held for the purposes of discussing public business. The board did argue that the gathering was not a meeting because the company had never submitted an application. There was no current public business with the company, and the meeting was not about county policies or procedures. However, the board confirmed that members engaged in a question and answer session about the company's proposed operations. The PAC held that the dinner was a meeting because it related to public county business, and the members in attendance engaged in a collective inquiry phase of the deliberations by gathering and exchanging information in anticipation of possibly taking future action. Unlike hypothetical lawsuits, the PAC is more interested in preventing the potential violation of public business, even if the project is hypothetical. So keep that in mind if you're invited to a lot of dinner parties. There are a number of amendments to OMA. Electronic training in OMA may be satisfied through township officials of Illinois organization as well as through the PAC. Again, they post their own training seminar or portal. There's a new section 2.07 that prohibits regular and special meetings on election days, even if your public body's regular meeting day falls on an election day. There's an amendment that members can now attend a meeting remotely if they're prevented from physically attending due to active military service. There's also an amendment that allows closed session discussions of self-evaluation practices and procedures of professional ethics when meeting representatives of a statewide or regional association tasked with handling professional ethics and self-evaluation. Now, are there any questions regarding the Open Meetings Act before I move on to FOIA? Yes.
When it comes to agendas, would you say the threshold is, a lot of times we get on tangents, it seems like, here on the board. Is there a threshold we should be looking for, or is it more just up to whoever's chairing the meeting to say, hey, we need to get back on task? When do we kind of get into that gray area where we shouldn't be talking about something because it's not on the agenda?
If you're taking a vote is one of the bright lines. If you're taking action on something that has not been placed on the agenda, that is a key point that you need to redirect, point that out that was not on the agenda, and reorient the conversation. If you're in a special meeting, you need to limit yourself solely to the topics that were on the agenda. During a regular meeting, things can go a little awry. That is accepted by the public access counselor, but you shouldn't be taking any action that is of the substantive nature if it's not on the agenda.
Okay, so if it's not an actionable item, we're really relying on the chair to just have control of the meeting.
That would be fair.
Okay, thank you.
Yes.
I just would also point out, though, that that is a pretty blatant and most often violation of Robert's Rules of Order, which according to our rules is how we're supposed to govern the meeting. So while it might not be actionable under OMA, it would be actionable under the board rules for appropriate behavior. And I think we often, as a body, veer quite far from that, and trying to remind people that that's, and I think I teach Robert's Rules, and that's probably one of the most frequent violations.
All right.
Any further questions on OMA?
All right, moving on to the fun part of the present.
Mr. Farney?
I do have one. So this the electronic recording of meetings. We're putting them out onto YouTube and things. We don't currently have a room microphone that's picking up, say, side conversations, or if somebody doesn't have their microphone turned on. Does the PAC give any guidance on what we should be doing as far as having things in place for that? Like, do they say we need to have a microphone on all the time to catch everything that's going on during the meeting? Or are we okay? And unfortunately, a lot of board members don't turn on their microphones when they should. Are we making ourselves liable to action by not having that kind of a all-encompassing room microphone?
Again, that gets into some hypotheticals that I would depend on the circumstance. I'm not going to address those specifically. I would say that the Open Meetings Act does not discuss specifics of recording equipment. It is a fairly older statute that has been updated with a number of considerations of electronic media. It does not specifically establish what recording equipment or technical standards for that. As long as the minutes and the agenda and the public access to the meeting is being adhered to, OMA is largely satisfied. What you under FOIA and record-keeping standards, that would be a different issue, but again, largely dependent on the circumstance. There's also the Local Records Act, which might discuss how you're handling certain digital media and its ultimate destruction and maintenance, but that's a separate conversation that we probably don't have time for. Yes.
I just want to add that not using the microphone hinders my ability to take minutes.
I think we're ready for FOIA.
All right. The fun times with FOIA. All right. My favorite section. Now, the Freedom of Information Act establishes that every public body, again, largely defined the same as a public body in the Open Meetings Act, must designate one or more officials or employees to act as their Freedom of Information officer. Those officers or their designees shall receive requests, records, and ensure that the public body responds to the requests in a timely fashion and issues responses under FOIA. The FOIA officer shall also develop a list of documents or categories of records that the public body shall immediately disclose upon request. That FOIA officer is primarily tasked with the efficient movement and recording of FOIA requests. They are also the primary point of contact for the public access counselor if they're reviewing FOIA decisions. That's who they're going to reach out to. That's who they're going to communicate with. That's one of the primary purposes of designating a FOIA officer. They may there is no requirement under FOIA that the FOIA officer be the specific one responding to every single request. As it notes, they can designate people to send FOIA responses, and there is no such violation as impersonation of a FOIA officer. That just should be noted. Electronic training for FOIA officers must be completed through the PAC system by FOIA officers on an annual basis. When a public body designates a new or additional FOIA officer, that person must successfully complete the training within 30 days of that designation. Again, that is so the PAC has someone to directly interface with if they're handling a review. FOIA officer registration, they are not required to register with the public access counselor. When they take the training, they list which office that they're representing and provide their contact information. That is the process by which they identify who the FOIA officer is. If you're not the organization's FOIA officer and you're taking one of the trainings, just designate not the FOIA officer. Otherwise, you'll start getting some emails that you might need to direct elsewhere. The purpose of FOIA, much like the Open Meetings Act, is one of openness. Under FOIA, all records in the custody or possession of a public body are presumed to be open to inspection and copying. Any public body that asserts that a record is exempt from disclosure has the burden of proving by clear and convincing evidence that it is exempt. When a FOIA request is received by an office, it must be initially reviewed to determine whether it is a commercial or non-commercial request and establish the timeline to respond. They then must review the request to determine whether any responsive information is available with their body or it needs to be redirected to another public office. FOIA requests need to be directed to the actual office that possesses that particular kind of information. The public body does not have a burden to direct it to the new public body or the appropriate public body, but may do so in an abundance of openness. When you're requesting the state's attorney's office to review a request or your own FOIA officer to review a request or situation, always attach the original request when discussing or inquiring about it. It's important to be very specific, as FOIA officers receive many requests through the course of the week, particularly with the rise of AI. There can be many requests from different people that request largely the same thing, or multiple requests from a single requester. So simply saying the request from X individual is not really going to help. It's important to be as specific as possible. Commercial versus non-commercial requests. A commercial purpose is is a person who it means to use any part of a public record or information derived from a public record for the purposes of sale, resale, solicitation, advertisement for sales or services. A request made by news media or another nonprofit, scientific, or academic organization is not considered to be made for a commercial purpose. When the principal purpose of that request is access to access and disseminate information concerning news or current or passing events, articles or opinion of features of interest to the public, or the purpose of academic, scientific, or public research and education. The important distinction between commercial and non-commercial: if it's a commercial request, a public body has 21 business days to respond to it. It's a much longer timeline. Most requests are not commercial in nature. They are requesting academic or news media or other information, not for the purposes of making money. For those requests, there are 5 business days from receipt of the request to respond to the request. Now, there is a response that allows us to extend the time period for specific circumstances, but that's dependent on that particular circumstance. Which is also why, if you receive a FOIA request, it is important that you direct it to your FOIA officer as quickly as possible so that they have adequate time to assess and respond to the request. Now, the county board members largely do not receive FOIA requests, but there are occasional FOIA requests directed to county board members. It's get those to the county executive's office as fast as possible, and they will discuss with you how that case is going to be handled. Does the request adequately describe an actual document? FOIA itself does not require answers to general questions regarding policy or fact-finding. It is not designed to compel the compilation of data that the government does not ordinarily keep, and does not compel the agency to provide answers to questions posed by the inquirer. Now, it's important to note that compilation of data or creation of a new record is not required by FOIA, but the Public Access Counselor has interpreted the Freedom of Information Act to require the public body to share information that is easily compiled from existing databases or compiled into a new document. The specific line at which creation of a new record is, it's creation of a new record or simply recompiling information you already have, is vague at best, and it's dependent on the situation. Requesters are obligated to reasonably describe what they're seeking, but an agency must be careful not to read a request so strictly that the requester is denied information before the agency, denied information the agency actually knows exists. They are not required to list a specific document name or file format or anything of that nature. It can be general enough to describe a range of documents. If the public body doesn't know what that document is specifically or has questions, they have to request clarification from the requester. I've included some template language that a FOIA officer might use at the bottom of this slide. Now, there are a number of special conditions that apply to FOIA requests. A FOIA request can be considered voluminous. That's a request that includes more than, includes more than 5 individual requests for more than 5 different categories of records, or a combination of individual requests that total requests for more than 5 different categories of 5 records in a period of 20 business days, or requires the compilation of more than 500 letter or legal-sized pages of public records unless a single requested record exceeds 500 pages. I would note that requests for emails, each individual email counts as a separate document. If they request all of a particular individual's emails from a period of a year, each is a separate document and would likely be over 500 pages. There is also the condition of unduly burdensome. Section 3G of FOIA lists that all requests calling for all records falling within a category shall be complied with unless the compliance would be unduly burdensome and there is no way to narrow a request. The burden on the public body would outweigh the public interest in the information. Unduly burdensome would, responding to the request would require significant output of effort and time on the part of the public body and prevent them from performing public service. This is a fairly limited standard and requires a specific pattern of response. You cannot invoke unduly burdensome if the initial 5-day timeline to respond has already passed. You lose the ability to invoke that. If the request is considered unduly burdensome, you need to give the requester the opportunity to refine their request. It can't simply be rejected out of hand. That is the most common mistake when handling unduly burdensome requests, and most commonly shot down by the PAC. And I already preempted my next slide. Again, opportunity to narrow, and you need to have a timely response in order to invoke unduly burdensome. Now, there are also recurrent requesters. This is becoming more and more common. However, it is fairly hard to hit the recurrent requester standard. It's a person that in 12 months immediately preceding the request submitted to the same public body, and again, public bodies, animal control and the state's attorney's office for the purposes have their own FOIA officer and are considered separate bodies. A minimum of 50 requests for records, a minimum of 15 requests for records within a 30-day period, or a minimum of 7 requests for records within a 7-day period. We often see 7 request emails within 1 minute submitted by the same requester. Those are considered separate requests for the purposes of FOIA, but until you hit number 8, it is not hitting the recurrent requester standard. And I'm just going to go back to voluminous. Again, 5 individual requests for more than 5 different categories of records. So each request of those 7 can ask for up to 4 different categories of records. So it is fairly hard to hit the annual limit and even the weekly limit for FOIA requests for the average person. And again, requests made by news media, nonprofit, scientific, or academic organizations can't be considered recurrent requesters. I'm going to jump into exemptions. Section 7 of the Freedom of Information Act lists a number of different exemptions that would exempt particular records or information within those records from disclosure. However, the public body may elect to redact the information that is exempt. It is not a requirement that that information be exempted and redacted. The PAC, again, construes these much like closed meeting exemptions very narrowly. There are sections A through TTT, so I'm going to mainly go through some highlights. Information specifically prohibited from disclosure by a federal or state law or rules or regulations implementing federal or state law. This is why the state's attorney's office receives so many referral requests or clarification requests, because there might be multiple statutes such as the Juvenile Court Act or HIPAA that might apply to a particular document outside of FOIA. Exemption D, records in the possession of any public body created in the course of an administrative enforcement proceeding and any law enforcement or correctional agency for law enforcement purposes, but only to the extent that would interfere with pending or actually or reasonably contemplated law enforcement proceedings conducted by law enforcement or correctional agency that is the recipient of the request. This is one of the most common exemptions that applies to law enforcement, such as the sheriff's office. We also see Section D has a number of subsections. The state's attorney's office most commonly deals with subsection 3, where request of records dealing with law enforcement, if disclosed, would create a substantial likelihood that a person will be deprived of a fair trial or an impartial hearing. More applicable to this body, proposals and bids for any contract, grant, or agreement, including information which, if disclosed, would frustrate procurement or give an advantage to any person proposing to enter into a contract or agreement with the body until an award or final selection is made. Information prepared by or for the body in preparation of the bid solicitation is exempt until an award or final selection is made. Complementing the Open Meetings Act and the closed meeting minutes, minutes of a meeting of a public body closed to the public as provided in the Open Meetings Act is not subject to disclosure under FOIA. Privileged communications are under Section 7(1)M. Communications between a public body and an attorney or auditor representing the public body that would not be subject to discovery and litigation, and materials prepared or compiled by or for a public body in anticipation of a criminal, civil, or administrative proceeding upon the request of an attorney advising the public body, and materials prepared or compiled with respect to internal audits of public bodies. I would like to note that privileged communication, when shared by your attorneys to you, is privileged unless you open it up to other people. If you share on privileged communication from the state's attorney's office, such communication loses much of the protection and may be subject to FOIA if you're forwarding on that information. Such information should be coming with disclosures from the state's attorney's office saying that this is privileged communication or a legal memo, something of that nature. So just bear that in mind if you're receiving information of from your legal team or an auditor, whether internal or external. Records, 7(1)N, records relating to a public body's adjudication of employee grievances or disciplinary cases. This exemption shall not extend to the final outcome of cases in which discipline is imposed. I do want to spend a quick moment discussing this one because the clear language would imply that all records related to adjudication of employee grievances or disciplinary cases is exempt. The public access counselor, however, in an abundance of narrowly construing this statute, says that only information expressly compiled or written during the administrative hearing itself is exempt, not material prepared in advance. So that might involve HR records or anything of that nature. It becomes much more broad than you would think. 7(1)P, records relating to collective negotiating matters between a public body and their employees or representatives, except that any final contract or agreement shall be subject to inspection and copying. In most cases, much like OMA, final determinations are subject to examination and FOIA as well as OMA. Now, there are several FOIA amendments, but before I move into those, I did want to discuss email services. I realize I did not put in a slide about this, but it is important to keep your personal and public accounts separate. If any of you maintain a personal email account as well as a public emailing service as a county board member, it's important to keep those services separate, as if you are receiving public business or conducting public business through your personal accounts or personal text messages, that might result in the potential inspection by the state's attorney's office or your FOIA officer, and ultimately the PAC. I will note that if PAC performs an examination, their role is to issue a determination. They do not release information directly themselves. Information disclosed to them is private, but they will determine whether they think we should or should not disclose information. If you're bleeding the edges of your private and professional accounts, that makes it a very gray area. Try and avoid that as much as possible. I will move on to FOIA amendments. The legislature amended the new section 3J. Within 5 business days after receipt of a request, a public body that has reasonable belief that a request was not submitted by a person may require the requester to verify orally or in writing that the requester is in fact a person. This is reflecting the rise of AI. Deadline to respond to the request is tolled until the requester verifies that they are in fact a person, and allows that the public body can deny a request if the requester has not confirmed they're a person within 30 days. Public bodies, however, may not require the requester to submit personal, private, or identifying information such as photo ID for the purposes of proving that you're a person. Again, this is in light of the rise of AI. Many of our public bodies have seen AI-generated requests, and we expect that to grow over the next couple of years. The primary consideration, however, under the PAC's analysis is that FOIA requests may still be anonymous. There is no requirement that you prove you are a particular individual or you're going to use information for anything except for the consideration of whether this request is commercial in nature. So the PAC is interested in protecting that interest, even considering the AI factors. There is a requirement that information regarding FOIA information be prominently displayed. A public body shall prominently display on its website information required by Section 4, that's FOIA officers, et cetera. However, that post may be at each of its administrative or regional offices if it does not have a website. They also amended Section 9.5F to add protection for any officer or employee of a public body that discloses records in accordance with an opinion of this office instead of just for the public body. There are several exemptions, such as 7.1D5, which added a number of different statutes to limitations for disclosure. And there's a new section, which 7.1UU, which personally amused me. Nuclear material information is now exempt from disclosure. Now, once a requester receives a response from the public body, they can appeal to the PAC or for judicial review. If you have a case or communication from the PAC or threatened lawsuit, please contact the state's attorney's office. The public bodies always include information regarding appeals or reviews or requests for review to the PAC in all responses that go out. All requesters, again, much like the Open Meetings Act, have 60 calendar days from the original FOIA request to file a review with the PAC. There are several recent FOIA binding decisions that I wanted to mention. I'm actually going to Section 7.1F exempts preliminary drafts, notes, and recommendations. I'm actually going to skip over this particular one as I think we're moving along on time. Are there any questions regarding FOIA or OMA? I can go back.
I have one. So without requiring someone to prove who they are, what is just the bare baseline for asking or for verifying that it is a person, not AI?
Sending an email or phone call to the contact information provided and requesting that person confirm that they are a person. If the AI is capable of sending back an email that says, I am in fact a person, we are still obligated to respond to that.
Okay, thank you.
So, yes.
I have a question about the definition of media. I think that mostly only applies to like the voluminous, thing. But it seems as if what is media is very much in flux. I feel like nowadays, just anybody could say, I'm the media. If they, have a Facebook page with two people who, so like, is there an actual working definition by the PAC of the term media?
There are a number of decisions that have assessed that was primarily an issue with a number of different blogs that request information as news media. There are a number of factors that are considered with that, including following, whether they're picked up by mainstream media for the reports, and a number of other things. So if that is the issue, again, contact the state's attorney's office and we can discuss that, because an analysis needs to be performed and an assessment of that blog or other media. Questions of whether Instagram or other media outlets constitute media requests hasn't really been discussed by the PAC at this point. Largely, we would most likely apply the similar standards as blogs. Yes.
Ernie?
I was at a meeting last night about data centers, and one of the things that got brought up is that some of the developers are asking entities to enter into non-disclosure agreements. And it would seem to me that an NDA would be a violation of FOIA.
NDAs
Have we
with
heard
public-
anything about that?
NDAs with public bodies are largely ineffective. FOIA does not really consider them at all. Most cases you would disclose. However, there are certain exemptions that the applicant, or this comes up in a number of bidding situations, that they can invoke, such as trade secrets, but they have to specifically identify that information. The contract would need to specifically include that. The contract should be referred to the state's attorney's office so that that specific language can be included, and that contractor can discuss what information and why they're wanting to exclude. But that, again, is dependent on what kind of information it is and why they're trying to restrict it. Most likely, a non-disclosure, well, in majority of situations, a non-disclosure agreement is simply not going to work. Our contracts are public.
Sure.
Any other questions? Thank you so much. We appreciate it. The greater viewing audience of more than one appreciates it, and we look forward to this again next year. Next on the agenda is discussions and questions. We've handled that. I have no other business. Seeing none, I call this meeting adjourned at 7:02 p.m.